Borstal is a village near London where the first British youth detention centre was established. Such centres therefore became known as Borstals, and the young men in them were known as Borstal boys, some as old as 23. Borstals were intended to rehabilitate and educate, whereas prisons at that time had no such intention. Borstal boys, as a result, were often not confined to their cells, as they began to prove themselves worthy of greater trust. In this case, a group of Borstal boys was taken to work on Brownsea Island near Bournemouth. Overnight, the guards pretty much left them unconfined. They swam out to a private yacht moored near the island, crashed it into another yacht, cast the second yacht adrift, and caused damage. The owners of the yacht obviously realised that suing the Borstal boys was pointless, as they would have no money to pay damages. Instead, they sued the Home Office, who were responsible for the Borstals and who employed the guards. The parties agreed that before the trial went ahead, a higher court should decide whether a defendant could be vicariously responsible for the negligent conduct of another party where the relationship between them was guard and prisoner. A majority ultimately said yes, but under strict conditions. Lord Diplock wrote the leading judgment. He said first that if the guards had been given a discretion to choose the level of overnight security which they felt was appropriate, then the court would not second-guess their discretion, and there could be no negligence. However, if the guards had no such discretion, if they were following rules set by the Home Office, then the Home Office could potentially be liable. Lord Diplock said any duty of a Borstal officer to use reasonable care to prevent a Borstal trainee from escaping from his custody was owed only to persons whom he could reasonably foresee had property situate in the vicinity of the place of detention of the detainee, which the detainee was likely to steal or appropriate and damage in the course of eluding immediate pursuit and recapture. This would depend upon the previous criminal and escaping record of the individual trainee concerned and the nature of the place from which he escaped. It followed that it was possible for the Home Office to be liable, and so the matter was returned to the lower court for trial.